joining us, so I'll just wait for them to attend. And we're now also live streaming on YouTube, and I think we'll be live on Instagram as well.
Excellent.
We've actually had over 1,000 people sign up to attend the event, so we hopefully have a big audience with us today.
Good afternoon, crew, and Assalamu alaikum.
Oh, walaikum salam.
Bonjour, Claude. Bonsoir, c'est pas bonjour. Hein?
Bonsoir.
Okay, so I think it's best for us to get started now. Welcome, everybody. I hope you're all safe and well, and thank you for attending this webinar about representing clients in a sports law dispute. Abu Dhabi Judicial Department is honoured to have you here with us today. The webinar will be bilingual, hosted in Arabic and in English, and it is important that you have version 5.4.3 of Zoom installed, as you will have read in your reminder email. This will allow the translation function to work. When you have the correct software installed at the bottom of your screen, you will see the icon interpretation. Please then select your preferred language, either Arabic or English, and this will allow you to listen to the webinar in your chosen language. So, for example, if you would prefer to listen to the webinar in Arabic, once you have selected that channel, you will only hear the Arabic translation. And this is the benefit of having such great technology at our disposal. In addition to this, we welcome interaction from the audience. Each speaker will talk for approximately 15 minutes, and they will have an additional 10 minutes to answer any questions you have. So I kindly ask that you type your questions during the presentations in the Q&A box, which is at the bottom of your screen. It is my pleasure to now introduce you to Mr. Faisal Al-Khoury, General Supervisor of Abu Dhabi CAS Sports Arbitration Center.
بسم الله الرحمن الرحيم. السلام عليكم ورحمة الله وبركاته. سعادة اللواء أحمد ناصر الرئيسي، المفتش العام بوزارة الداخلية بدولة الإمارات العربية المتحدة، رئيس اتحاد الإمارات للفروسية، السادة السيدات والسادة الضيوف الكرام، يسعدني أن أرحب بكم جميعا في ورشة عمل اليوم بعنوان تمثيل العملاء في النزاعات الرياضية التي يستضيفها مركز التحكيم الرياضي في دائرة القضاء بأبو ظبي. إنه في شهر ديسمبر من العام المنصرم 2020 استضفنا 20 خبيرا في القانون الرياضي لمدة يومين كضيوف متحدثين، وتم تغطية موضوعات مختلفة متعلقة بقانون الرياضة، مثل طرق منع وفض النزاعات الرياضية ودور محكمة التحكيم الرياضي في عالم الرياضة. كان بينهم لاعب سابق في الرابطة الوطنية لكرة السلة يناقشون قانون الرياضة من منظور اللاعبين ومنظور الإدارة. وفي مستهل هذه السنة 2021 في شهر يناير أقمنا ندوة افتراضية بمناسبة صدور القانون العالمي الجديد لمكافحة المنشطات، وتشرفنا بحضور السيد برنت نورويكي رئيس قسم مكافحة المنشطات في كاس الذي تولى إدارة هذه الفعالية. كما يسعدني أن تم استقطاب عدد كبير من الحضور تعدى أكثر من 30 دولة حول العالم. كما تعلمون، يهدف مركز التحكيم الرياضي في أبو ظبي أن يكون أحد أفضل مراكز كاس في العالم من خلال تقديم خدمات ذات مستوى عالمي وتثقيف المجتمع حول قانون الرياضة، مع التركيز على الإجراءات والقوانين المهمة المطروحة على الساحة الرياضية. وكما هو الحال دائما، أنا على ثقة من أن هذا الحدث سيكون ناجحا للغاية، حيث ضيوفنا المتحدثين يتميزون في مجال قانون الرياضة. وأود أن أنهي كلمتي بالإعراب عن أمنياتي لجميع المتحدثين بالتوفيق والسداد. وأتوجه مرة أخرى للشكر لجميع الحضور، وأخص بالشكر سعادة اللواء أحمد ناصر رئيسي اللي أعطانا من وقته الثمين، والشكر للأستاذ كلوي والمتحدثين وضيوفنا من جميع دول العالم. والسلام عليكم ورحمة الله.
Thank you. Thank you so much. I'm now honored to introduce to you His Excellency Major General Dr. Ahmed Nasser Al-Razi, General Inspector of the Ministry of Interior in the UAE and President of the UAE Equestrian and Racing Federation.
السلام عليكم ورحمة الله وبركاته. سعادة الأخ فيصل خوري، كل الشكر لك على الدعوة وأيضا التقديم الجميل. الله يحفظك وإن شاء الله يوفقك في مهامك. الأخوة المتحدثين في هذا الملتقى المهم حقيقة لنا جميعا كرياضيين في دولة الإمارات العربية المتحدة التي تولي الرياضة أهمية قصوى. السادة الحضور الكرام، أسعد الله مساءكم بكل خير. أود أن أعرب في البداية عن شكري لمركز أبو ظبي للتحكيم على دعوتهم الكريمة للمشاركة في هذا الحدث، وأشيد أيضا بالأهمية الكبيرة التي يجب إليها الاستضافة وتنظيم الفعاليات والمنتديات والمؤتمرات الرياضية الدولية بهدف رفع مكانة الإمارات العربية المتحدة. أثبتت أبو ظبي طيلة فترة الوباء أنها وجهة جاذبة لصانع القرار الرياضي ونجوم الرياضة الدوليين. أرحب بكم اليوم بصفتي رئيس اتحاد الإمارات الفروسية والسباق الذي تأسس عام 1992 بتوجيه من المغفور له الشيخ زايد بن سلطان آل نهيان مؤسس دولة الإمارات العربية المتحدة طيب الله ثراه. ويتولى هذا الاتحاد الإشراف وتنظيم جميع أنشطة الفروسية في جميع أنحاء البلاد بهدف بناء قاعدة واسعة للرياضة وإعداد الأجيال القادمة. وتتمثل رؤيتنا في جعل الدولة مركزاً للفروسية على المستوى العالمي مع مراعاة الثقافة والتراث الوطني، وأن نكون مصدر فخر وإلهام ونشر روح الفروسية بين الصغار والكبار، وغرس حب الخيل والإحساس بهذا المخلوق النبيل في قلوب الجميع. كما أنني في نفس الوقت رئيس لمجلس إدارة نادي بني ياسر الرياضي الثقافي، وهو نادي إماراتي يشتمل على كرة القدم وكرة الطائرة وكرة اليد والتنس والطاولة والمبارزة والجوجيتسو، بالإضافة إلى العديد من الرياضات الأخرى. ويرأس سيدي سمو الفريق الشيخ سيف بن زايد آل نهيان نائب رئيس مجلس الوزراء وزير الداخلية هذا النادي. واستجابة لهذا أيضا للوباء وأيضا التكاتف في هذا الوقت، أصدر رئيس مجلس أبو ظبي الرياضي الشيخ نهيان بن زايد آل نهيان توجيهات للأندية الرياضية في أبو ظبي لإتاحة مرافقها ضمن برنامج معا نحن بخير الذي أطلقته هيئة المساهمة المجتمعية لمنح المجتمع فرصة لدعم جهود الحكومة في مواجهة التحديات الصحية والاقتصادية الحالية. ولقد دعمنا البرنامج من خلال إتاحة جميع مرافقنا للأفراد في منطقة الشامخة للاستفادة منها، وشمل ذلك صالة الألعاب الرياضية وملعب كرة الطائرة وقاعة الجوجيتسو وجميع مرافق النادي. في الختام، يعد مركز أبو ظبي للتحكم الرياضي كاس إنجازاً ضخماً لتعزيز الأساس الجوهري لصناعة الرياضة في الشرق الأوسط والعالم بشكل عام. وتعتبر هذه الفعاليات التي يستضيفها مركز أبو ظبي للتحكيم الرياضي منصات مهمة للغاية للمساعدة في زيادة الوعي بالرياضة. ويهدف المركز إلى ترسيخ العدالة المنصفة للجميع في المسائل المتعلقة بقطاع الرياضة، ونتطلع إلى بناء شراكات دولية للمساهمة في دعم التنمية والتقدم وفتح آفاق جديدة يمكن من خلالها القطاع الرياضي الإماراتي أن يحقق أهدافه المتمثلة في التميز والاحتراف. مع تمنياتي لهذا الملتقى بالنجاح، وما في شك أنه بينجح بإذن الله بوجود هذه النخبة المتميزة من المتحدثين اليوم اللي إن شاء الله بيضيفون الكثير. شكرا لكم مرة ثانية، شكرا لك الأخ فيصل، وأيضا للقائمين على هذا الملتقى المتميز.
Oh, Shukran, thank you so much, Your Excellency, for your great welcoming speech. It's an honor to have you here with us today, and thank you so much for taking time out of your schedule to speak at this sports law event. It's now time to introduce you to our first guest speaker, Mr. Max Shepherd. Max is a practicing barrister based in London and has been instructed by national and international federations, clubs, and players in a variety of matters. His recent cases include advising on jurisdiction, player contract disputes, and a significant appeal against the Rugby Football Union before the National Anti-Doping Panel. He frequently advises and represents clients in anti-doping matters at all stages of proceedings and is the chairman of the International Mixed Martial Arts Federation Anti-Doping Committee. The topic he will address today is jurisdiction, dispute resolution, and key issues to consider when representing athletes and organizations. Thank you, Max.
Thank you, and thank you very much for the kind introductions. Good evening, everybody. My name is Max Shepherd, and as you've heard, I'm the chairman of the International Mixed Martial Arts Federation Anti-Doping Committee. Now, I know MMA has a strong presence in Abu Dhabi, Yas Island, of course, being home to the UFC for practically the entirety of the pandemic, and really one of the biggest sporting events to remain consistent during the pandemic. On top of that, Abu Dhabi is host to the famous Abu Dhabi Combat Club, so I really am honoured to be speaking here today. My segment of this workshop, as you heard, is on jurisdiction, dispute resolution, and key issues to consider when representing athletes and organisations. I think it's important to say now that my view is jurisdiction and dispute resolutions are two key things to consider in anti-doping proceedings too. I'll be focusing on some of my experiences when representing clients in anti-doping matters in the National Anti-Doping Panel and try to give everyone some key takeaways from my times doing so. When I get to key issues, I'm going to focus on putting organisations to proof, mitigation, and costs. And those are really the three topics I'm going to cover under key issues. So I'm conscious that we have a lot of people with varying levels of sports law knowledge watching this. So before I go into detail about jurisdiction, I think we first need to understand what I'm really saying. So jurisdiction is the authority of a court or tribunal to make rules, laws, or legal decisions. But this can also include enforcing rules, laws, or legal decisions. So jurisdiction is really the first legal argument that an athlete can mount once a tribunal is convened, and one of the first hurdles that federations must overcome before they get to a substantive hearing. If jurisdiction is something that's being contested, let's say hypothetically speaking, I'm acting for the athlete, then I tend to ask for a preliminary hearing to determine jurisdiction. It has the cost-saving effect if you're successful, as there's no preparation necessary for a final hearing. And if you're not successful, well, then you're not successful and you are where you were anyway. Now, broadly speaking, jurisdiction is established in a few different ways. Rules tend to vary, not tend to vary, but tend to give around 3 different ways for athletes to be covered and say something like the organization has jurisdiction over. So firstly, all players and player support personnel who are members of any member union or association. Now, just a note on member union or association. So those tend to include affiliate organizations or any member union. And that can include any club, team, local union, association, or league. So it really is quite a big catch-all. And most of these terms have definitions within the rules. So secondly, all players and player support personnel participating in such capacity in events are likely to be caught by jurisdiction in the rules. And then thirdly, any other player or player support personnel or other person who by virtue of an accreditation, registration, or other contractual arrangement is subject to the jurisdiction of the International Federation, or then it often lists lots of different federations. So those are the 3 main ways that the rules identify how jurisdiction applies to players. Now, jurisdiction, certainly when I've done them, tends to be a question of fact. Questions can be quite simple and things like, was the athlete a member of a club, or did the athlete compete at an event? Or perhaps was an athlete on the register of members? Now, if an athlete signed up to the rules, then there's normally very little wiggle room for them if they're playing when registered with the organisation, and panels seem to be quite quick to accept jurisdiction. It can be slightly more technical arguments if jurisdiction is reliant on a contractual arrangement to be bound by the rules. And in those circumstances, you may very well have some, as you might expect, contractual arguments. Jurisdiction within most sets of rules also includes jurisdiction to be tested. But I think for the purposes of today, and considering I've got 15 minutes to speak to you, I'll be focusing on jurisdiction challenges at the tribunal. It is an interesting area because what an athlete says when challenging jurisdiction can often double up as mitigation. What I see in a lot of cases is athletes saying, I've retired or I'm not playing anymore. I'd be careful with that if you're representing the athlete, because most sets of rules often have a set process detailing how athletes can retire, and sometimes a period after that in which they remain bound by the rules. In reality, most of the time, there will be a paper trail. You're likely to have something somewhere where an athlete has agreed to be bound by the rules. An athlete can also be bound by conduct. So if an athlete plays in a particular game, for instance, the rules often provide that an athlete be bound by the anti-doping policy. This means that even if an athlete doesn't sign up to the rules in writing, it's possible that their conduct as such means they're bound by the rules anyway. So I think the next question is, what does jurisdiction mean when we get to a hearing? Now, the test across most organisations that I've seen is the panel has to be satisfied to a comfortable satisfaction that there has been an anti-doping rule violation. Now, I know that's not quite jurisdiction, but it seems that built into that is the principle of jurisdiction. Now, that test can vary, but it generally means that the test applied, as in the standard of proof, is higher than the English civil standard, which is on balance of probabilities, and lower than the English criminal standard, which is beyond a reasonable doubt. This means that before an organisation can even show that there has been an anti-doping rule violation, they have to first show that the tribunal has jurisdiction, and the burden is on them. If an organisation is unable to prove to the requisite standard that the tribunal has jurisdiction, then that's the end of the case. The rejection of jurisdiction is, generally speaking, dispositive, and that's the phrase they use, of the proceedings. Now, I would hazard a guess that jurisdiction is quite often challenged in these tribunals. When looking at jurisdiction challenges, however, the case law from CAS and anti-doping panels is fairly one-sided. Something athletes must remember is that ultimately the decisions that get published are ones where it was found that there has been an anti-doping rule violation. What that means is all of those cases where the athlete is successful in challenging jurisdiction will be private. This in turn means that if you're acting for an athlete and challenging jurisdiction, you're unlikely to find any helpful case to support your own case when you're doing your own research. So the next topic is dispute resolution. And if I were to work through this chronologically, a lot of the key things to consider actually start during the investigation stage, which is when a sporting body is trying to build evidence against the athlete. Often an athlete will have already had a test, received an adverse analytical finding, and have been charged, quote unquote, by the time I'm instructed. From an athlete's perspective, it's always best to have advice as soon as possible. 99% of the time, athletes will be going through this process for the first time. I think it's important for lawyers to bear that in mind when advising athletes and be sensitive to their needs. So if an athlete has tested positive for a prohibited substance, what are the steps? An organisation first investigates the reasoning, and if no agreement can be reached, it then refers the case to an independent panel so it can be resolved. For a lot of sports institutions in the UK, the National Anti-Doping Panel, which is run by Sport Resolutions, is the main independent panel. As I outlined earlier, there is often an overlap between jurisdiction and mitigation. When someone says they're retired, it can double up as mitigation and can potentially lead to a reduction of sanction, which we'll get to shortly. As a brief outline, sanctions vary, and the structure of burdens and standards also vary. There are too many to go through in the short time available here, but I will be giving you some common areas of mitigation that I've come across later. Now, a big part of dispute resolution is negotiation, which is a big subsection of what I'll be talking about today. The rules can be quite complex and the case law is a labyrinth, and there is always litigation risk. Something that should always therefore be considered is negotiation. Most organisations and anti-doping agencies will try to negotiate. If the athlete has tested positive for a substance, putting the burden on the athlete, however, then a good strategy from an organisation's perspective is to leave the athlete to show how the prohibited substance got into the athlete system, and that it wasn't intentional. An athlete would have to show both of those things before getting any reduction in any event, and the burden would be on the athlete as it is anyway. So unless an athlete can show these things on balance of probabilities, an organisation is unlikely to budge from their position, and really there's no reason to give an athlete a reduction. These negotiations often take place on a without prejudice basis. Now, for those of you not familiar with that term, as it's not a term globally used, it's correspondence or conversation that cannot be used as evidence in the case. And the reason that's a thing is to encourage settlement between parties. They are a form of privileged communication. Now, without prejudice communications can also be good for settling a dispute in part of the proceedings. That is to say, not the substantive dispute. An athlete or organisation can make offers to settle satellite issues without prejudice communications as well. Now, I mentioned earlier that putting organisations to proof was going to form part of this talk. Now, if you're an athlete, as I said, the best thing you can do is get representation quickly. But athletes will often try to say something, and even if they believe what they're saying to be true, if it turns out to be inaccurate, that can potentially have an adverse impact on their case. Everything said has to be balanced and really does have to be accurate. There was a case of Mark Dry not too long ago who received a 4-year sanction. And one of the key takeaways from that case, reading the decision, was that he tried to lie and then admitted the lie. Had he had representation right at the outset, the circumstances might have been different. That's not to say that athletes can stay silent either. Although I haven't seen an express provision for adverse inferences, in my case, the Rugby Football Union and Goodfellow last year, the first instance panel ultimately said they thought Mr. Goodfellow's refusal to give an immediate and frank answer to a question was a material consideration when finding that he acted intentionally. Now, that case was subsequently overturned on appeal, but what it does show is that you have to answer diligently, as diligently as you can, in fact, and refusing to give answers during the course of an investigation or litigation does not seem to be an option panels look upon favourably. Some organisations will have a collaborative approach to understanding how a positive test has occurred. In the scheme of things, this means organisations tend to work with the athlete to understand what has happened. Whilst from an organisation perspective, it's a collaborative approach, the important thing to remember when defending an athlete in anti-doping cases is that the athlete is still being investigated and potentially faces an arbitration and sanction as a consequence. Organisations don't want adverse outcomes for athletes that haven't committed anti-doping rule violations. Organisations want the correct outcomes for the athletes that committed anti-doping rule violations. That means that if an athlete has acted intentionally in taking a prohibited substance, then the organisation will want a sanction that reflects that. Now, my experience with a lot of organisations is that their perspective of what an athlete may have done or not have done is exceptionally important. Understanding precisely what happened prior to relaying it to an organisation is crucial. The athlete needs to understand what happened so they can understand 3 things. Firstly, they can understand what the potential sanctions are and what they're facing. Secondly, how to argue the case properly before a tribunal. And thirdly, to see whether there's any room for negotiation. Now, we discussed negotiation earlier, and in terms of settling the substantive element of an arbitration, what these negotiations ultimately boil down to is an organisation making what they think is a fair offer of a sanction based on their perspective of what the mitigation is. A big part of anti-doping proceedings is mitigation. Now, what constitutes mitigation can really only be determined on a case-by-case basis. The key limbs of mitigation that I'm going to address today are firstly that an athlete didn't act intentionally, secondly that the athlete bears no significant fault or negligence, thirdly that the athlete bears no fault or negligence, and fourthly substantial assistance. Now, before you get to no significant fault or negligence or no fault or negligence, you have to first get over the hurdle that the athlete didn't act intentionally. So those two, so no fault or negligence and no significant fault or negligence, are not available to an athlete if they don't first overcome the intentional hurdle. Now, in very broad terms, the way it works is that if there's a finding of not intentional, then the sanction is reduced by 50%. With no significant fault, an athlete can get the sanction down to a further reprimand, depending on their level of fault. The way to look at it is like a sliding scale. If no significant fault is found, but there's still a relatively high degree of fault in the context of no significant fault, then you can technically receive the same amount as if the finding of no significant fault hadn't been made at all. This happened in the first John Jones case. John Jones is a UFC fighter with well-known anti-doping decisions. Whilst the panel in that case found that he bore no significant fault or negligence, they still gave him the maximum they could within that bracket. The better position for an athlete is if there's a finding of no fault. The sanction is much lower, as you'd expect. And if there's a finding that the athlete bears no fault, then a period of no eligibility is made. Now, something that's not very or not spoken about very much is substantial assistance. So there is also a mechanism whereby athletes can get a reduction of their sanctions by reporting others who may be committing anti-doping rule violations. This is offered in a majority of cases and is generally at least outlined in open correspondence. So most organisations will tell you that a key way to get a sanction down is by substantial assistance. Now, it's rare we hear about substantial assistance being provided, but again, quite a famous case where we know it was the second John Jones case. In that case, it resulted in a significant reduction in John Jones's sanction. Each of these different aspects of mitigation have an entire body of previous decisions to go with them. There are other ways of reducing sanctions too, but these are really the key ones. Understanding each of them is so important from both sides. From an athlete's perspective, you're going to want to know what sanction you're potentially facing following the positive test. And from an organisation's point of view, you need to know what you can sensibly argue at the hearing while still being fair to the athlete. From both sides, knowing the precise circumstances of the case is important, as it may very well help with negotiations. Now, finally, I've got a consideration which isn't addressed much at a domestic level, and that's costs. I've only got a short section on this, as costs are rare in the National Anti-Doping Panel, but they should certainly be a consideration. The general approach to costs is that each party bears their own costs. Ultimately, the tribunal would need to find that an argument advanced by a party was frivolous or otherwise entirely without merit to award costs against a party. That bar is quite high, which is why I suspect that these orders are rarely made. But I think both sides, organisations and athletes, need to be conscious that cost orders can be made. This factor isn't a significant consideration for a lot of people, but clients on both sides need to be aware that there is an option for tribunals, at least at the preliminary stages. So to recap, the key things to consider from both sides are, firstly, jurisdiction. So from an athlete's point of view, can the organisation show that the tribunal has jurisdiction in this case? From an organisation point of view, they're probably going to be thinking the same. It is a waste of money for all parties if the organisation can't prove jurisdiction, so there is no point continuing if the organisation can't get over this hurdle. Then we have negotiation. This as well can be a cost-saving tool on both sides. As with any form of litigation, I would always encourage this, albeit cautiously. There is no need to go to a hearing if everyone is in agreement about everything. If you're not in agreement about anything, which does happen, then you're going to have to go to a hearing. Thirdly, putting the organisations to proof. This is a very hard balance to strike between assisting the organisation in their investigation and protecting your position as an athlete. You won't want to seem obstructive if you're an athlete, because it can be perceived that you're hiding something, but by the same token, a lot of athletes won't want to exacerbate their position, which is also understandable. And then finally, mitigation. What reductions on sanctions can the athlete get, and how do they go about doing it? Are you liable for any costs? And if so, what costs? So everybody, thank you for listening to me. Those are my key considerations when doing anti-doping cases. And that also concludes my segment of the talk. Thank you, everyone, for listening. And if there are any questions, please don't hesitate to ask in the chat box.
Hi, Max. So we have some questions already. Sure. You can hear me? Max, you can hear me?
Yes. So what is the conflict between the two judgments between the CAS and the Sports Arbitration Court, which is in the country? What provisions will be applied? Yeah. So I think the question is there a conflict between a first instance decision and a CAS decision? So CAS decisions are, I think I'm understanding the question properly. CAS decisions or CAS hearings are ordinarily de novo. So the hearing will be heard entirely again and from scratch as if it was the first time. Therefore, the underlying decision from the from the first instance country. So for instance, the National Anti-Doping Panel is what I've been talking about a lot. That decision, I say is irrelevant, but it's sort of secondary. So the CAS decision takes priority over that. I think there's a different way of interpreting the question as well, and that's how do you in a tribunal differentiate which decision that has more importance, I think, so a CAS decision or another decision. What I find is case law in practically all doping tribunals, it is a matter of convincing the panel that what you're saying is accurate and what the opponent is saying is not the best course of action, because what you're saying, there's a body of case law, and what the others are saying, there is conflicting case law. If that's not quite what you're asking, I apologize. And if there are any other questions.
Max, so I'll just read out the questions from the Q&A
sure.
to you. So
Sure.
Zuhair Faruqi is saying, you mentioned that it is best for athletes to get representation as early as possible. How
Sure.
can legal practitioners and athletes best work with each other or reach out to each other to achieve this?
So I think that's very hard, because often an athlete's not going to come to you until they've got a problem, especially as a lawyer. Often higher level athletes will have law firms on retainer, or law firms that they use frequently for other matters, so full service law firms. I mean, I think having the athlete as a client predating any positive test or any adverse analytical finding or any anti-doping rule violation allegation is probably the only way you're going to do that. Otherwise, a proactive athlete is the other way, I suppose. An athlete that says, oh, I'm in trouble here, or I'm potentially in trouble here, let's go and get some representation. Because really, the only time that they're going to be considering a lawyer is the moment they get a positive test back. It's pretty unlikely they're going to come to us prior to that point. There's no need for them. It's completely pointless.
Okay, great. Thank you very much. And the next question is, what is the primary criteria for the jurisdiction of CAS?
So I think often within an organization set of rules, there will be a CAS jurisdiction written into that. So you will say the National Anti-Doping Panel, to give an example, the National Anti-Doping Panel is the first instance panel. The athlete has a right of appeal to the appeal panel within the National Anti-Doping Panel. And then ordinarily it gives 4 or 5 people that can appeal to CAS. So jurisdiction is ordinarily written into the rules. Okay. I have just seen another question. Isn't it possible that the highest court in a country can exercise its constitutional right and act against the National Anti-Doping Panel? So I think the most recent and public case of this is the Sun Yang case, where the CAS decision was overturned by the Swiss Federal Tribunal. I vaguely recall it was on the basis of discrimination. In fact, I think that might be the only manner in which it is overturned. But yes, no, that is possible because the Swiss Federal Tribunal just did it. So yes.
Okay, and the first question that you got asked was from Tarek Deeb, and he says, will CAS look at cases that have, I think what he's trying to say is, will CAS look at cases where they already have a judgment from a local court?
Will CAS look at cases where they have a judicial decision from a local court?
Yes, exactly.
I don't see why not. As in, I'm assuming that's talking about an underlying decision. Then yes. I mean, it doesn't bear a factor into their consideration because, as I said before, it's de novo, so it's completely new. So even if there is an underlying decision from the previous National Anti-Doping Panel, wherever that may be, it's irrelevant for the purposes of CAS because they're just hearing it again.
Okay, perfect. Yes, we have another question from Mohammed Ahmed. He says, what if there is a conflict between 2 judgments between the CAS and he says the Sports Arbitration Court, which is in the country, what provisions will be applied?
So between the case law of CAS, I'm guessing, I think that question's pretty easy perhaps, because CAS itself has conflicting judgments. So you're always going to get a body of case law with conflicting judgments. I don't see ever, certainly given the amount of cases that come out, that you're ever going to have a consistency of judgments across the board. So my guess is domestic courts of arbitration for sports or domestic tribunals will be more likely to adopt theirs, but I don't think that's a hard and fast rule.
Okay, perfect. I think most of the other questions are in relation to anti-doping, and I know that we'll be addressing perhaps answering some of those questions through Claude's speech and Rupert's speeches later on. So I think that's all for now, Max. Thank you so much.
Perfect. Thank you
for your help. Okay, perfect. Okay, now I'll introduce you to our second speaker, Mr. Nasser El-Dinazam. He is an international sports lawyer and lecturer of sports law. He represents players, clubs, federations, and authorities in sports-related disputes before international sports bodies such as CAS, FIFA, FIBA, and IOC. He is a former professional football player and is a member of the International Association of Football Lawyers. His topic today is transfer windows, player contracts according to the new FIFA regulations, and best practices when representing
We can't hear you.
Or players.
I think mute.
Oh, you can hear me? Okay, good. When representing clubs or players in football-related disputes before the CAS, AFC, and CAF. Thank you, Nasser. And Nasser, you're just on mute.
Thank you, Klu. Thank you for your introduction, and I'm honored to be here with my dear colleagues and for the Alternative Hearing Center of CAS in Abu Dhabi and the Judicial Department of Abu Dhabi, and of course General Dr. Ahmed Nasser. We thank him for being our guest of honor today. I see that my dear colleagues are they are more standing in Arabic, so I will be making my presentation shortly in Arabic. So if people want to turn or to change the audio to Arabic. بسم الله الرحمن الرحيم. طبعا احنا النهارده يعني بنتكلم على افضل الممارسات في تمثيل العملاء في المنازعات الرياضيه. يا ريت تاكيد هل كله الناس سامعه كده كويس بالترجمه؟ اوكي. طبعا بشكر يعني زميلي العزيز ماكس على البرزنتيشن المهمه لموضوع المنشطات، وهي فعلا من اهم الامور في الرياضه دلوقتي، وبقى ليها تاثير كبير جدا على الامور في الرياضه. وطبعا التاثير بتاعها ده ممكن زي ما احنا بنشوف ان في ابطال عالميين بيخسروا البطولات بتاعتهم بسبب حاجه ممكن يكون ما عندهمش قصد فيها. يمكن انا الجزء المشاركه بتاعتي هتبقى اكتر على كره القدم، ولكن هيبقى فيه في الجزء في الاخر برضو متعلق بالمنشطات برضو في كره القدم. هعمل بس شير للبرزنتيشن سريعا كده معاكم. واضح البرزنتيشن عندكم ولا لا؟ واضح كده؟
لا.
Yes, we can see it.
طيب طبعا سريعا الجزء الاولاني احنا هنتكلم على اهم التعديلات اللي الفيفا عملتها. الفيفا الفتره الاخيره بتعمل مراجعه للوائح بتاعتها في انتقالات اللاعبين، وده طبعا بسبب تطور الانتقالات وسوق الانتقالات على مستوى العالم كله. اهم التعديلات الحديثه دلوقتي، واحنا شايفين طبعا تاثير كوفيد 19 او فيروس كورونا على انتقالات واوضاع اللاعبين. بقى الفيفا كان زمان اللائحه ما بتسمحش للاعبين ان هم يلعبوا غير لناديين فقط اثناء الموسم. يمكن التعديل الجديد اللاعبين بقوا بيتم ممكن تسجيلهم في 3 انديه مختلفه اثناء الموسم، وممكن كمان يلعبوا ل3 أندية مختلفة أثناء الموسم. فدي تعديل جديد، وده عشان يدوا مساحة للاعبين في ظل تأثير فيروس كورونا ان هم يقدروا يلعبوا لأكتر من نادي. طيب لما احنا بنيجي بنتكلم طبعا عن المنازعات الرياضية، اشهر حاجة دايما عندنا هي المنازعات المتعلقة بالفسخ اللاعبين او الأندية العقود من طرف واحد. ويمكن التحديث جديد برضو مهم جدا للفيفا اللي هو الابيوسيف كوندكت او السلوك التعسفي، ان اي طرف من الاطراف بيعمل سلوك تعسفي لاجبار الطرف الثاني على انهاء التعاقد، هنا ممكن يحق للطرف المتضرر ان هو يفسخ العقد من طرف واحد والرجوع على الطرف اللي بيعمل هذا التصرف التعسفي بالتعويض. ودي طبعا بيحصل، ونلاقي ان ممكن انديه كتير بتعمل سلوك معين مع اللاعبين وبيحصل بعد كده نتائج بتبقى سلبيه على اللعيبه. التعديل الجديد برضو هي ماده جديده تم اضافتها اللي هي ماده 14 مقرر 14 بيس. الفيفا اقرت ان اللاعبين ممكن ان هم يفسخوا العقود بتاعتهم لو ما خدوش مرتباتهم لمده شهرين، ولكن في شرط ان هو لازم يعمل انذار للنادي بدفع المبالغ المستحقه خلال 15 يوم. لو النادي ما دفعش خلال 15 يوم بيحق ساعتها للاعب ان هو يفسخ العقد من طرف واحد، وفي نفس الوقت بيرجع على النادي بالتعويض وممكن بيبقى ليه الحق في كامل قيمه عقده بالكامل. ودي طبعا هنشوف الامثله العمليه ونقول ان الانديه بتاعتنا لازم خاصة في المنطقة العربية بتقع ساعات كتير في المشاكل دي وبتسبب ديون كبيرة على الأندية. الحاجة الجديدة كمان إن في مسألة ملكية الطرف الثالث لحقوق الاقتصادية بالنسبة لانتقالات اللاعبين. الفيفا يمكن دلوقتي بقى مسموح إن ممكن للاعب، هو في منع طبعا إن ما ينفعش يبقى فيه ملكية طرف ثالث، ولكن حديثا تم السماح للاعب إنه ممكن يملك جزء من مقابل انتقاله لنادي تاني. يعني على سبيل المثال مثلا بن شرقي مثلا بيلعب في نادي الزمالك، ممكن يبقى هو في اتفاقه مع نادي الزمالك ان لو انتقلت النادي جديد انا اخد جزء من ترانسفير فيه او من مقابل الانتقال، وده برضو بقى مسموح بيه دلوقتي. في نقطه اخيره هنتكلم على السوليداريتي ميكانيزم او اللي هي مساهمه تضامنيه. احنا بنتكلم دايما شايفين مثلا محمد صلاح ما شاء الله في ليفربول دلوقتي انتقل وكان في روما وبعد كده راح لليفربول وبيبقى مقابل مالي كبير اكتر من 40 مليون يورو. هنا الانديه اللي كانت بتدرب محمد صلاح في فتره الشباب بيبقى ليهم نسبه حوالي 5% اللي هي المساهمه التضامنيه. الفيفا برضه عملت تعديل جديد ان حتى لو محمد صلاح نفترض دلوقتي انتقل مثلا من نادي ليفربول لنادي تاني داخل نفس الدوري في انجلترا، ان برضه الانديه اللي كانت بتدرب اللاعب اثناء فتره التنشئه يبقى ليها برضه حق في السوليداريتي. وده برضو تعديل مهم عشان بيدي الحقوق للانديه اللي كانت بتدرب اللاعب في مرحله في الاول ان هم يقدروا ياخدوا تعويض عن التدريب ده. طيب خلينا نتكلم طيب بالنسبه للتجارب العمليه. طبعا احنا من خلال التجارب العمليه مع انديه كتير في منطقه الميدل ايست طبعا او في الشرق الاوسط المنطقه العربيه بنلاقي ان في منازعات فيها خصوصيه كبيره جدا لينا احنا هنا. يعني بنلاقي ممكن المنازعات دي ما بتحصلش على مستوى خارجي بسبب ان احنا برضه بيبقى لينا خصوصيه معينه. هنتكلم في البدايه ان اهم مرحله في المراحل المنازعات الرياضيه هي المرحله اثناء التعاقد. يعني البيست براكتس بالنسبه لاي نادي او اي لاعب هو انت ازاي وانت بتعمل التعاقد في كره القدم ازاي تبقى متاكد ان التعاقد بتاعك ده ما فيهوش اي مواد مخالفه للوائح الاتحاد المنظمه للعبه. وبالتالي بندي مثال دايما ممكن في انديه كتير بتعمله، ان ممكن تعمل عقد مع لاعب كره قدم وتحط في هذا العقد ان لو اللاعب لم يعني ما قدرش ان هو ينجح في الكشف الطبي اللي هيتعمل ان هو يفسخ العقد من طرف واحد. طبعا هنا الشرط ده مثلا مخالف للوائح الفيفا التي لا تسمح بفسخ العقود من طرف واحد من الانديه لو اللاعب لم ينجح في الكشف الطبي. وعلشان كده مثلا ندي مثلا نادي الوحده الرياضي يمكن كان في تعاقد مع احدى اللاعبين من نادي ريد ستار من صربيا كان في 2019. العقد كان تم فعلا مع نادي ريد ستار على شراء اللاعب مقابل مبلغ مالي معين، وكان اللاعب لسه هيسافر لعمل الكشف الطبي ولكن لم يتم توقيع العقد مع اللاعب في الوقت ده. اللاعب بعد لما جه ابو ظبي عمل الكشف الطبي ما نجحش في هذا الكشف الطبي، فتم اختار نادي ريد ستار بانهاء العقد من طرف نادي الوحده، وبالتالي هنا كان في نزاع ما بين اللاعب وما بين نادي ريد ستار ضد نادي الوحده ان ما يجوزش ان انت تفسخ العقد بسبب الموضوع الكشف الطبي. ولكن هنا كان الرد على هذه النقطه، وهنا البيست براكتس اللي احنا بنتكلم عليه، ان انت ما ينفعش تحط الشرط ده في عقود اللاعبين، لكن لو موجود في عقد الناديين ده يجوز، ده ما فيش فيه مشكله. لكن المهم ان هو ما يكونش مضيت عقد ما بين النادي وبين اللاعب في شرط ان هو يفسخ العقد من طرف واحد لو ما نجحش في الكشف الطبي. وعشان كده قدرنا نجحنا في ساعتها في نادي الوحده، وطبعا كان السي او طبعا صديقي العزيز خالد الهنائي. وحصل برضو نقطه مهمه جدا، ودي برضو نصيحه دايما للانديه او اللاعبين، ان حصل اجتماع مباشر ما بين نادي الوحده وما بين نادي ريد ستار في صربيا، ودايما في جزء كبير زي ما انا بتكلم في المنازعات الرياضيه هو حلها في المرحله الاولى بيبقى مهم جدا من خلال التعامل المباشر، ومن خلال ان انت تكون بتراجع العقود بتاعتك ما يبقاش فيها اي شروط مخالفه تسبب لك اضرار بعد كده. طيب لما هنيجي نتكلم بالنسبه للمنازعات اللي في كره القدم، ايه اللي انا اقدر استعين بيه كدليل؟ ايه الافيدنس اللي ممكن تكون متاحه للانديه او للاعبين؟ بنلاقي ان كل الوسائل متاحه، يعني زي اي تقاضي انت ممكن تلجا طبعا للعقود، لو في شهاده شهود، لو في اي مراسلات رسميه، كل الامور اللي انت عايز تستعين بيها لاثبات حقوقك دي متاحه. ولكن خلينا نبقى واخدين بالنا برضو في جزئيه مهمه دايما بتبقى عندنا فيها خطأ شويه، ان بنستعين ساعات برسائل الواتساب، او دايما في تعاملات اللاعبين مع الانديه انها تعتمد على الواتساب. هنلاقي ان الفيفا بتقول ان الواتساب مثلا ما بيبقاش دايما دليل كافي لاثبات حقوق الاطراف، وبالتالي برضو بيبقى من المهم ان يبقى المراسلات بتاعتنا بتتم من خلال الايميلات الرسميه اللي موجود منصوص عليها في التعاقد، علشان يقدر ان هو يتم الاخذ بيها بعد كده. طيب في نقطة مهمة جدا برضو ألا وهي مراكز الاستماع البديلة للكاس. يعني بالتعامل احنا طبعا برضو في المنطقة العربية ان احنا الكاس مثلا موجودة في سويسرا، طبعا احنا بنروح بنحضر الجلسات هناك في سويسرا، ولكن في بعض الأحيان بيكون بعض الأطراف اللي احنا بنمثلهم في القضايا زي مثلا اللاعبين أو وكلاء بيبقى مش قادرين ان هم يسافروا لارتباطهم ببعض المباريات، وهنا بيبقى نقطة مهمة جدا وجود المراكز أو فروع للمحكمة الرياضية الدولية في زي ما موجود في أبو ظبي، تقدر إن أنت تحضر جلسة الاستماع أمام مركز الاستماع اللي موجود في أبو ظبي، وده بيسهل. وده حصل معايا طبعا في بعض اللاعبين بدل ما هم يسافروا لسويسرا ما يقدروش طبعا هو كده، لكن بيحضر، وساعات بيبقى المحكمين موجودين من نفس المنطقة وبيبقى الأطراف كلهم من نفس المنطقة، وده بيوفر طبعا تكلفة السفر للوزان، ودي بتبقى نقطة كمان مهمة جدا. سريعا هناخد بعض الأمثلة عشان نشوف برضو إيه المنازعات اللي ممكن تكون متعلقة بكرة القدم. مثال النزاعات ممكن يبقى الموضوع متعلق بالإيمج رايتس أو اللي هي حقوق الصورة، زي مثلا على مثال محمد صلاح. كلنا عارفين قبل كأس العالم 2018 كان محمد صلاح عنده نزاع مع اتحاد الكرة المصري حوالين استغلال الصورة بتاعته، لأن محمد صلاح هو متعاقد بشكل شخصي مع شركة فودافون في مصر، وكان اتحاد الكرة متعاقد مع الشركة الأخرى اللي هي شركة وي. وزي ما احنا شفنا هنا الطيارة اللي كانت عامل التصميم بتاعها لوجود محمد صلاح بشكل كبير بالصورة بتاعته بعيد عن اللعيبة جنب رعاة الاتحاد. وهنا محمد صلاح طبعا عمل ساعتها لو انتم فاكرين التويته الشهيره ان هو متضايق. وهنا برضو ان بنشوف ان ساعات ممكن الامور القانونيه بتجيب لك حقك، لكن برضو محمد صلاح مجرد ما هو قال ان انا متضايق اتحاد الكوره فورا مصر كلها اتقلبت طبعا لان نجم كبير، وتم حل هذه المشكله وتم اعاده تصميم اللاعبين على الطياره اللي بيها محمد صلاح بعد عن الراعي اللي موجود للاتحاد. حاجه تانية برضو موضوع اللي احنا اتكلمنا عليه السوليداريتي ميكانيزم، ده طبعا لاعب طبعا حسين الشحات لاعب النادي الاهلي وكان لاعب العين الاماراتي، اللاعب طبعا انتقل من نادي العين الاماراتي للنادي الاهلي المصري مقابل 5 مليون دولار. وهنا الانديه اللي كانت بتعمل تنشئه للاعب حسين الشحات في الفتره اللي هو من سن 12 سنه لسن 23 سنه بيستحقوا نسبه 5% من انتقال هذا اللاعب، وبالتالي هنا الانديه في مصر اللي دربت اللاعب قدروا ان هم برضو يحصلوا على نسبه من السوليداريتي في انتقال هذا اللاعب. ودلوقتي بقى الموضوع ده بيتم عن طريق السيستم بتاع الTMS للفيفا، وبقى بيتم بشكل في تطور كبير جدا عشان تقدر ان انت تضمن الحقوق بتاعتك المتعلقه بالتنشئه، سواء تريننج كومبنسيشن او السوليداريتي. طيب احنا بنتكلم دلوقتي على تاثير كوفيد وشفنا قضايا كتير جدا، بس في حاجات ممكن نتخيل ان هي ما تحصلش. عندنا حادثه جديده، تصفيات كاس افريقيا ما بين منتخب غينيا الاستوائيه ومنتخب ليبيا. انتوا عارفين ان اللوائح دلوقتي بتاعت الفيفا بتسمح ان ممكن 5 لاعبين ان هم يشاركوا في المباراه، ولكن على 3 تغييرات فقط او 3 توقفات زائد ما بين الشوطين. يمكن الحاله القضيه بتاعتنا المباراه تم عمل 4 تغييرات من منتخب غينيا في المباراه، ولكن ال4 تغييرات دول تموا اثناء المباراه، يعني تم ايقاف المباراه 4 مرات، وبالتالي في لاعب المفروض هنا شارك بالمخالفه في حدود ال5 لعيبه ولكن في توقف اضافي. هل شايفين ان هنا الحكم يطلع ايه؟ هل ان نادي منتخب غينيا يخسر المباراه، ولا ان طالما ما تجاوزوش ال5 تغييرات انه يبقى كده التغيير سليم؟ هو طبعا الموضوع في اول درجه في داخل الاتحاد الافريقي تم رفض شكوى اللي احنا كنا عاملينها للاتحاد الليبي لكره القدم، ولكن احنا حاليا بنستأنف هذا القرار قدام المحكمه الرياضيه الدوليه، وهنشوف قريبا هيكون الحكم اللي موجود هل ممكن يغير الحكم اللي صادر من الاتحاد الافريقي ولا لا. سريعا في حاجه زي مماثله برضو، كان نادي روما في الدوري الايطالي او في كاس ايطاليا كان اشرك 6 تغييرات وهو المفروض ما يعملش اكتر من 5 تغييرات، وبالتالي الاتحاد الايطالي خد قرار ان هو يعتبر خاسر للمباراه 3-0 كحاله مماثله لهذا الموضوع. وهنا بيبين برضو تاثير كوفيد 19 وتعديل اللوائح الجديده اللي بتتم، ان ممكن بيبقى بعض المنتخبات مش عارفين ان هم التعديلات دي وبيبقى في اخطاء زي كده. طبعا عندنا كان حاله برضو للامور الانضباطيه زي قضيه النادي الاسماعيلي، كان مع الاتحاد الافريقي كان تم استبعاده من بطوله ابطال افريقيا في 2019، ولكن برضو كنا عملنا في الاستئناف. وهنا ازاي تثبت عدم وجود خطأ؟ كان السبب الاستبعاد هو اقتحام الجماهير للملعب المباراة او وجود شغب من الجماهير، ولكن تم الاثبات واحنا بنعمل في جلسة الاستئناف ان ما فيش كان اقتحام للملعب. ممكن يكون كان في رمي بعض الادوات للملعب، ولكن ما كانش فيه اقتحام للملعب، وبالتالي خدنا قرار من الاتحاد الافريقي لجنه الاستئناف باعاده النادي مره ثانيه للبطوله. وهنا كان الحاله ان انت استعنت كمان بشهاده الفريق الثاني اللي انت كنت بتلعب معاه، ودي بتبقى من اهم برضو طرق الاثبات هي شهاده الشهود. اخيرا طبعا كلكم عارفين قضيه محمود كهربا، هو دلوقتي لاعب النادي الاهلي، كان في نادي الزمالك وانتقل لنادي في البرتغال، وبعد كده رجع بعد 4 شهور للنادي الاهلي. يمكن الحاله دي اتحكم فيها فعلا بقرار من الفيفا بغرامه كبيره حوالي 32 مليون جنيه مصري على محمود كهربا والنادي البرتغالي لصالح نادي الزمالك، والقضيه حاليا برضو في امام الكاس بيتم النظر فيها، وممكن اللعيب او النادي البرتغالي يبقى فيه عقوبات رياضيه عليهم كمان، وده اللي احنا هنشوفه خلال الفتره الجايه بسبب فسخ اللاعب كان ساعتها العقد اثناء فتره الحمايه. ودي فتره الحمايه الفيفا بتوضعها عشان تحافظ على مبدا استقرار العقود بالنسبه للانديه واللاعبين. اخيرا طبعا انتوا فاكرين كان طبعا الامارات استضافت دوله الامارات العربيه استضافت بطوله اسيا الاخيره، ويمكن كان حارس منتخب العراق تم استبعاده قبل البطوله دي بسبب ظهور بعض الماده منشطه كان في بطوله انديه بطوله ابطال اسيا، وكان الماده دي ماده اسمها ماده السوبوترامين. اللي حصل ان بسببها تم استبعاده من البطوله، ولكن حضرنا في القضيه دي، وهو يعني طبعا زملائي كلود وماكس طبعا هيتكلم عن النشاطات برضو بشكل كبير والادله اللي ممكن يستعين بيها، ولكن نخلي بالنا احنا الرياضيين عندنا ان ساعات بنستعمل بعض المواد او بعض الادويه اللي غير يعني معلومه او ما نبقاش عارفين بدون استشاره الطبيب. وهنا برضو كان خد دواء للتخسيس بشكل عادي، ولكن الدواء ده كان فيه ماده محظوره اللي هي سوبوترامين، وبسببها كان معرض ان هو يتم ايقافه 4 سنين، ولكن في مرحله التقاضي قدام AFC الاتحاد الاسيوي وحضور الجلسه لجنه الانضباط تم تخفيض العقوبه دي ل4 شهور فقط، بسبب ان احنا اثبتنا ان العلبه اللي اللاعب كان بياخد منها الفيتامين ده كانت مش مكتوب عليها الماده دي، وبالتالي هي تعتبر كونتامينيتد او الماده نفسها موجوده في العلبه ولكن مش موجوده من بره، وبالتالي اللعيب ما كانش يقدر يعرف. عايز اختم اخيرا برضو بما اننا اتكلمنا عن المنشطات بحاجه بره كره القدم، ولكن ظريفه جدا وحاله طريفه، وبتثبت برضو مساله العداله بالنسبه للمنافسات الرياضيه. زي ما احنا عارفين اللجنه الاولمبيه الدوليه دلوقتي بدات ان هي بتعمل ريتست. يعني ايه ريتست؟ يعني دلوقتي مثلا دوره الالعاب الاولمبيه في 2008 في بكين او 2012 كانت في لندن، في ناس كسبوا وعملوا طبعا تحليل المنشطات في وقتها، ولكن في 2016 اللجنه الاولمبيه الدوليه عملت العينات دي بتقدر تحفظها من 2008 و2012 في معمل بيتم الحفاظ على هذه العينه، وعملوا ريتست مره ثانيه او اعاده تحليل مره ثانيه للعينات للناس اللي خدوا ميداليات في 2016. اكتشفوا ان بعض الناس دي كانوا واخدين ماده محظوره اثناء المنافسات، وبالتالي يمكن وسائل الكشف على المنشطات في الوقت ده ما كانش قادر يكتشفها، ولكن طبعا مع التطور التكنولوجي بدا ان هم يقدروا يكتشفوا الحاجات دي، وبالتالي تم حرمان بعض الرياضيين اللي خدوا ميداليات في 2008 و2012 من الميداليات بتاعتهم. ويمكن كان عندنا لاعيبه رفع الاثقال عبير عبد الرحمن، هي لاعيبه رفع اثقال، هي اول سيده مصريه تحصل على ميداليه اولمبيه، وهي سبحان الله في 2016 كلموها في التليفون قالوا لها الف مبروك انت كسبتي ميداليتين اولمبيتين، ميداليه في 2008 في بكين وميداليه في لندن 2012، بسبب ان الناس اللي قبليها في الترتيب كان تم استبعادهم بسبب المنشطات، فترتيبها اتحسن، خدت ميداليه فضيه وميداليه برونزيه. وهنا بيبين على اهميه طبعا موضوع الريتست على موضوع المنشطات اللي بيبقى مهم جدا للرياضيين. انا طبعا بشكركم جدا، واي اسئله طبعا الموضوع مختصر، انا هحاول ابعت لكم برده حاجه مكتوبه بس تحت امركم في اي اسئله. شكرا جزيلا.
Thank you very much, Nessa. I've got some questions for you that people have asked during the presentation. So the first question is, do local lawyers have to have a special accreditation to submit a case to CAS, or does it need to go through another Swiss lawyer?
بشكل عام ان انت تبقى معاك ترخيص عشان تمثل اطراف او تقدم قضيه في المحكمه الرياضيه او في الفيفا، لا مش شرط يبقى عندك ترخيص معين، ولكن طبعا لازم ان انت تكون كواليفايد او تكون مؤهل للعمل ده عشان تقدر ان انت تقدم حاجه زي كده ويبقى عندك الدرايه بيها. لكن لو حاجه هتكون قدام المحاكم السويسريه لازم تكون ان انت محامي معتمد داخل سويسرا. لكن بشكل عام احنا بنقدر بنمثل الاطراف في المنازعات قدام الفيفا او قدام الكاس بشكل طبيعي طالما ان انت بيبقى عندك القدره على هذا العمل يعني.
Okay, excellent. The next question is, how can you become a sports law arbitrator?
طيب طبعا هو المحكمين الرياضيين، انا مثلا موجود انا كمحكم في مركز التحكيم السعودي الرياضي، بيتم دايما اختيار من مراكز التحكيم سواء في الكاس او في الدول بشكل مختلف، اللي تكون مؤهل بيشوف انت خبرتك القانونيه وايه برضو مدى المامك بالرياضه. وهنا اهميه التحكيم الرياضي ان انت بتقدر يكون ناس عندها خبره قانونيه وخبره رياضيه ايضا. يعني انا مثلا كنت لاعب كره سابق مثلا في ناشئين في نادي الزمالك، وفي نفس الوقت في الناحيه الرياضيه مع الناحيه القانونيه، فممكن بيتم اختيارك في حاجه زي كده، ولكن ده الشروط العامه اللي بتبقى موجوده يقدر يتم اختيارك في مراكز تحكيم. احنا عندنا برضو في مركز تحكيم رياضي جديد في الامارات.
Thank you. Okay, so another question. Please clarify the requirement to pass the medical examination in more detail. Assuming that the player does not pass the medical examination, how can the club guarantee his right when the contract is impossible to implement?
أنا سمعت السؤال صحيح. Did I hear the question right? How to guarantee your right in a contract with a player without putting اللي هو medical clause, huh?
Yes.
Okay. This is a situation what we ده الحالة اللي احنا عملناها مع نادي الوحدة الرياضي، ان احنا بيبقى في تعاقد كان مع النادي وفي الشرط ده، ولكن مع اللاعب ما كانش التعاقد بيتم توقيعه لغايه لما يعدي الكشف الطبي، فبالتالي تقدر ان انت يبقى في زي ممكن نيجوشيشنز مع البلاير وتقريبا اتفاق على الشروط، ولكن لازم اللاعب يجي الاول يعمل الكشف الطبي، وبعد لما يتجاوز الكشف الطبي تقدر تمضي معاه العقد، وهنا تضمن حقك مع اللاعب وفي نفس الوقت تضمن حقك ان انت ما تتعاقدش مع لاعب ممكن يكون عنده اصابه وانت مش عايز تتعاقد معاه.
Okay. Does FIFA communicate with football clubs to educate them about the updated regulations?
يمكن حاليا الفيفا فعلا في تطور كبير جدا فيها، وفي يعني برامج جديده اتعملت للمديرين في الانديه في كره القدم من الفيفا، بالتالي يقدروا يعرفوا اللوائح الجديده. زائد في كمان دبلومه الفيفا هي موجوده في جامعه القاهره، وموجوده كمان في ابو ظبي، اعتقد في جامعه السربون في ابو ظبي، دي تبع CIS مركز الدراسات الرياضيه الدوليه في نيو شاتيل، يمكن انا بدرس فيها في جامعه القاهره. الفكره ان انت الناس كتير جدا بيدخلوا هذه الدبلومه بيقدروا ان هم يحصلوا على خبره في مجال الاداره او في القانون، ودي طبعا متاحه من خلالها. الفيفا بتعمل برامج كتيره جدا، وفي مؤتمر هيكون الشهر الجاي الفيفا هتنظمه للمعرفه حوالين اهم التعديلات واهم المستجدات في لوائح الفيفا ايضا يعني.
Thank you so much. The next question is, in the event that a player transfers to a different club, does this affect sponsorship rights?
Sorry, again, the question, please.
Sure. If a player transfers from one club to another, does this affect any sponsorship that they have?
Okay. زي ما احنا قلنا ان التريننج كومبنسيشن او اللي هي حقوق الرعايه اللي احنا بنتكلم فيها دلوقتي، كان ممكن مثلا اللاعب ينتقل جوه الدوري ما يبقاش ليه حق للانديه، لكن الان بقى ممكن لو انت لاعب انتقل داخل نفس الدوري ان يكون ليه حقوق في التريننج كومبنسيشن بتاعه، او سوري في السوليداريتي. اما بالنسبه للتريننج كومبنسيشن بيبقى في نظام دولي، يعني لو لعيب انتقل اول مره ويعمل عقد احتراف خارجيا، هنا بيبقى التريننج كومبنسيشن في انتقال دولي. داخل الاتحادات المحليه بيبقى الاتحاد المحلي او الاتحاد الوطني، زي مثلا اتحاد كره القدم الاماراتي، اكيد بيبقى بينظم العلاقه. لو لاعب عمل عقد احتراف مع نادي، ممكن يبقى كل الانديه اللي كانت بتدربه وهو هاوي ياخدوا اللي هو حقوق الرعايه او تريننج كومبنسيشن يعني.
Thank you. Okay, the final question for NASA. Is the penalty for doping imposed on the player or the club?
العقوبه دلوقتي بيتم فرضها على اللاعب فقط، وبالتالي لو احنا مثلا في مباراه كره قدم وبعض الرياضي ده تم ادانته في بمنشطات، الفريق كله ما بيخسرش المباراه. عكس مثلا في العاب تانية زي مثلا ممكن يكون في اللي هو السباق الجري، ممكن لو في سباق تتبع يعني 4 وواحد طلع عنده منشطات، لا ممكن يخسروا كلهم الميداليه بسبب ان دي لعبه معتمده بشكل فردي. اما الالعاب الجماعيه لو لاعب ثبت عنده منشطات ما بيتمش استبعاد او خساره المباراه للفريق. ولكن في نقطه مهمه جدا، يمكن الحاله اللي انا اديتها للاعب العراقي حارس منتخب العراق، لما كان في لاعب تاني معاه عنده نفس الماده، الاتحاد الاسيوي عمل تحليل لباقي اللعيبه كلها عشان يتاكد هل الفريق كله بشكل جماعي كان بياخد بشكل المنشطات دي ولا دي حاله فرديه. لو كان تم اثبات ان دي حاله جماعيه وفي ستيت دوبينج او في اللي هو الفريق نفسه بيدي منشطات للاعبين كلهم، لا هنا ممكن يعتبر المنتخب خسران. ويمكن عندنا الحاله بتاع روسيا واستبعاد الرياضيين الروسيين من الالعاب الرياضيه الفتره الاخيره بسبب الموضوع اللي هو الستيت دوبينج او ان هو في منشطات لكل اللاعبين.
Thank you, Nasser. That was great. Now it's time to introduce our third speaker of the event, Mr. Claude Ramoni, who is a Swiss qualified attorney at law, specializing in advising and representing clients in the field of sports and business law. Claude advises and represents clients from the world of sport, such as national and international sports federations, clubs, and athletes in various areas, including doping matters. He regularly acts as counsel before the Court of Arbitration for Sport, judicial bodies of sports federations, or Swiss State Court. He will be talking today about the tactical approach to be adopted by athletes suspected of doping when defending themselves before the CAS and the risks associated with each strategy of defense.
Thank you very much, Chloe. Good afternoon, everyone. It is a pleasure to be here in this webinar organized by the Abu Dhabi CAS. It is even a bigger pleasure for me that I am in Switzerland. You can see it's a bit rustic environment because I'm in the mountain and there is snow all around. So it's even better to be in Abu Dhabi with snow all around me. So I will start sharing the presentation of today about the approach and how an athlete suspected of doping can basically which tactic and how they can defend themselves before the CAS. And now, here we are. So when we speak about a doping case before CAS, we need to make a distinction because now before the CAS, you can have two divisions of CAS dealing with anti-doping matter. So the first one is the CAS anti-doping division, which is a relatively new division, which is empowered to take first instance decision. So it means when there is a doping case, the federation has to prosecute the case. Some federations, including the IOC, for example, have appointed the CAS anti-doping division in order to issue first instance decision. So as it is a first instance decision, it means that there will be a full case review with a prosecution by the federation and then the athletes defending themselves. And it is a first instance, everything is on the table, all facts have to be established as a first instance body. The second possibility to go to CAS in a doping case is the CAS appeals division. So when there is a first instance decision already issued about a doping case, then the matter can be brought to the CAS. Here again, there are two possibilities. Either there is a first instance decision, the athlete is not happy with the first instance decision and will go to CAS to challenge the decision, or there is a first instance decision which is relatively favorable to the athlete, and then the anti-doping organization, WADA, the IOC, the International Federation, can appeal to the CAS and ask possibly for a sanction or for a stronger sanction. Sometimes no one is happy with the first instance decision and both go to the CAS. It is also possible here to have an appeal against CAS first instance decision, so against the CAS anti-doping division decision. To start with, when an athlete is accused of having committed an anti-doping rule violation, basically there are two possibilities, two tactical possibilities which exclude one and the other. The first one is to challenge the offense. So it means the athlete will submit, he disagrees, he did not breach the rules. Of course, if the athlete succeeds, it's a full success, then there will be no sanctions at all. He can keep his results if it was in competition, and he will be not sanctioned at all. On the other hand, if the athlete is not successful, then he will get possibly a harsher sanction. The other possibility is for the athlete to admit the offense, not to challenge that a breach of rules occurred, and then to plead only the existence of the sanction. So it means the matter and the dispute will be about which sanction should apply in the case at hand based on the specific circumstances, but it is not to challenge the positive case. What is important here to choose, I would say, what to do in a case is the concept of the burden of proof. Because here it is a special matter in anti-doping matter. The anti-doping organization has the burden of establishing whether an anti-doping rule violation occurred or not. But once it is established, then the athlete has the burden to prove in certain, if there is a non-specified substance or depending on the offense, of the kind of substance, it is the athlete who has to prove the absence of intent. The athlete also has to prove how the substance entered his or her body. The athlete has to prove his degree of fault. So to make a long story short, it is the athlete who has the burden to prove the circumstances of his own case once an offense has been established. And of course, if the athlete challenged the offense, then the athlete will not be able to prove what happened and why the substance was present in his body. So it means it's difficult to play on both hands. And that's why the athlete has to choose quite early in the process which strategy he or she wants to adopt. As a first part of the presentation, we will address the issue of the athletes challenging the offense, which is the athlete do not agree that they have committed an anti-doping rule violation. And here I can see three different possibilities for an athlete. The athlete can challenge the accusation completely, say either the facts are not right or those facts have not committed an offense. This would most probably happen in a case which is not analytical one, so it means there is no positive sample. It's, for example, coming from the inquiry or a whistleblower information, and the athlete can try to challenge that the facts and the offense. Other option, also to challenge the offense, is to say, okay, the facts in itself are not challenged, but the athlete may challenge that those facts constitute an offense. And the third possibility is the athlete does not really challenge the facts, but claims that there is a breach of the international standards. So it means the rules that govern how anti-doping organizations have to do their work have not been complied with, and this should nullify the positive case. I will give you some examples to make it clearer. Those cases about athletes contesting the facts, there have been a very, very large number of cases here. It is the cases of the Russian athlete in Sochi, because you probably heard or know that in Sochi there are accusations that there have been urine substitution, that the anti-doping laboratory was helping athletes to substitute their dirty urine with clean urine during the night. And this case, for example, is 3 girls practicing biathlon, and they were challenging that they had done that. So basically the CAS did not find that those substitutions did not occur, but the core of the matter was to know whether the athlete had been involved in those malpractice or not. And the athlete were challenging everything and contesting that this actually happened. In those cases, some athletes have been successful and others not. The distinction between the athletes is for some athletes, there were very strong evidence that their urine was not normal. There was too much salt in the urine. It was not normal to have that much salt in the urine. And the panel held, if there is too much salt in the urine, it is not physiological. It means that there has been manipulation. And in order to switch a dirty urine against a clean urine, you need some help of the athletes, because the clean urine has to come from somewhere. So those athletes have been sanctioned. The other one, there was not enough evidence according to the CAS, and they've been cleared of any offense. So you can see here, it's either everything, and the one have had the maximum ban, or nothing, and they've been completely released and are deemed to be innocent. Other possibility to challenge the offense is not contesting the analytical results, but to say those results are not an offense. And this is notably the case when the athlete claims that he or she should be entitled to a therapeutic use exemption. So what it is possible, according to the World Anti-Doping Code, that when an athlete requires a prohibited substance for a valid and genuine medical reason, to be authorized to use the substance. And in some cases, when there is an emergency, when the substance was used in an emergency, it is possible for the athlete to apply for a retroactive authorization to use the substance, which means the athlete does not ask in advance to be authorized to use the substance, but once the athlete is positive, he filed a request to be authorized to use it for medical reasons. And this is what happened to this girl, this shot putter Yang Gao. She had an injection of cortisone before a competition, and she tested positive. And here, she first submitted that the injection was an authorized one because it was not in a muscle. This was not accepted by the CAS, and she also claimed yes, but it was for a genuine medical reason because she had a back problem, and there was no therapeutic alternative, and therefore this should have been authorized. And it was accepted by the CAS. So you see, in those cases, the athlete does not challenge the positive case, but the challenge is about whether the positive case and the use of this injection of steroid, of glucocorticoid or cortisone, was authorized for medical reason or not. The third possibility where athletes challenge the offense, and not necessarily the facts, is the breach of international standards. So those standards, there are many of them, they are adopted by WADA and fix the rules which have to be followed in order for testing to take place. And I will make a short example with this case of Campbell Brown. So what happened? When there is a urine test, there is a minimum quantity of urine to be provided. And if the athlete is unable to provide enough urine, there is a specific procedure to be followed. Then there is a partial sample, so part of the urine, it's not enough, it has to be sealed. And then when the athlete is ready to provide more urine, the athlete will provide more urine until it will be mixed with the first urine. In that case, instead of sealing the first urine sample, the doping control officer simply gave it back to the athlete. And the athlete waited in the waiting room with her bowl with urine under her seat. And then she returned a positive test, and the athlete was able to submit with the support of experts, and I'm looking forward to the next presentation to hear about it, about the role of the experts, that it was possible to have contamination due to the fact that urine was kept in an open container, and therefore she was successful. The breach of the standard, the breach of the obligation to seal, could have been the cause of the positive test, and she was cleared from any wrongdoing. So this is for the first, I would say, tactic of the athletes challenging the anti-doping rule violation. Other possibility is to accept the anti-doping rule violation and then to plead about the sanction. It is not that easy because the athletes have the burden of proof to demonstrate what happened to have a reduction of the standard sanction, and we've heard that in the first presentation today. I will go quickly through some examples. The first aspect, the first layer, I would say, to be proven is whether the violation was intentional or not intentional. Because depending on the substance, if it's intentional, it is a 4-year ban, which can be reduced down to 2 years if the athlete can prove that he didn't cheat intentionally. And in that case of the boxer, Mr. Cameron, it was a case of cocaine. And cocaine is, at the time, is not a specified substance, and the standard sanction was a 4-year ban. And the boxer brought a kind of bizarre explanation that the cocaine was coming from money and banknotes, that there were bets before the fight, and he had a lot of banknotes, and probably the cocaine was on the banknotes. And this explanation was not valid scientifically. So therefore, the panel held, okay, you have to prove your absence of intention. You bring us a bizarre story which is not truthful. So therefore, the panel held that he did not prove the absence of intent to use it to dope, and therefore he was sanctioned with a 4-year ban. Other athletes have been more successful in the matter, but this is the first possibility. Then once the sanction is set based on whether it's intentional or not, the second aspect, the second thing that the athlete is to prove is the degree of fault. Degree of fault means the athlete is to prove how the substance entered the body, and then can prove that the level of fault justifies either no fault at all or a no significant fault. And I will give you an example that there are many cases of that. They've been contacted, is the case of food contamination. Because what happened, that the beef or other cattle are sometimes given substances to grow better, and it's forbidden, but this is used in food in order to feed the cattle. And if there is this substance in the meat, this can be found in the body and in the urine of an athlete. And of course, if this is proven that in fact the positive test comes from meat contamination, meaning the athlete did nothing more than just eating a steak, this is considered usually as no fault. There is no fault of the athlete, and he did not breach any rule, and then there will be no sanction. The difficult part here is for the athletes to prove that it actually came from contaminated meat. Because how can you remember or prove what you ate as a piece of meat 6 months ago? You have not kept a little piece in order to have it analyzed. So there are those two cases. Yannone, the CAS, held that he had not proven how the substance entered his body. And this Canadian girl doing a triathlon, Ms. Janicki, it was proven. So it is all a matter of assessing evidence to see how or whether the athlete has proven how the substance entered the body or not. In cases where there is no fault, so it means there is nevertheless a fault, it's still possible to apply for reduced sanction between a warning and 2 years, depending on the level of fault and depending also of the kind of substance involved. But again, it is for the athletes to bring this proof. So in that case of Mr. Cadogan, it was a matter of no significant fault. It is a substance. He explained to the panel that he had a headache or was not feeling very well, and he wanted to use a painkiller. But by mistake, he took a wrong pill, a pill of his teammate, which was furosemide, which is a prohibited substance. And he took the wrong pill by mistake, and therefore he would deserve as a reduction of the standard sanction of 4 years, reduced down to 2 years. And in that case, basically, the player, so the athlete, has to prove what happened. So first, has to prove how it entered his body, that his story makes sense, and then it is a first hurdle. And then he has to prove, based on all circumstances, that I would say his fault was excusable. And then, depending on the degree of fault, the CAS will decide. So in the case of Mr. Cadogan, he had only a very, very little reduction. He had a 20-month ban instead of 24 months, which is low reduction, because the CAS held, yes, but in that case, taking a wrong pill is still quite significant as a fault, so it's quite a high level of fault. So then it will depend on the circumstances. It can be the fault by the doctor, perhaps you will get a higher reduction, or if it was used for medical reason, or if it was used as an emergency treatment, depending on the circumstances, you can have a higher or a lower sanction. But again, it is the athlete who has to prove what happened. In a sense, this is normal because anti-doping organization cannot guess what happened, but then it is what is difficult. So to close more or less this 15 minutes presentation, it is in anti-doping, the sanctions are rigid, meaning there is not so much flexibility for the deciding body. There is not so much flexibility for the CAS. So usually, if there is a dispute before the CAS says either it is about whether violation has been committed. And then if there is a dispute about the violation, then the CAS has to decide, is it a breach of the rule or not? But then when we speak about the sanction, then usually quite often the maximum sanction will apply. Because of course, if the athlete says, I did nothing wrong, and the CAS holds that, no, you're wrong, you did something wrong and you committed a breach of the anti-doping rule, then the athlete has not provided any explanation how the substance entered his or her body, or to show that his fault, viewed in the totality of circumstances, is not significant. So then the athlete will have a 4-year ban. So in those cases, usually, it's all or nothing, either the maximum or then no sanction at all. Or then in the other cases, then the athlete has to accept that he committed an offense, meaning that the result will be cancelled. And if this is, for example, an offense committed on the occasion of the Olympic Games, it means the athlete will lose his or her Olympic medal, which is already quite a harsh sanction. But then the discussion will be about the sanction, and the sanction can go as low as no fault, meaning no sanction at all, or it can be a warning or just a couple of months suspension instead of 2 or 4 years ban, meaning that the athlete can continue his or her career. So with this, this concludes my today's presentation, and I would be very happy to answer any question you may have.
Excellent. Thank you so much, Claude. That was really interesting. We have a few questions. You might have already answered them in the presentation, but it probably would be helpful for the audience if you could repeat the answers. So the first question is there a runs between domestic and international rules relating to doping, and if so, which one will apply?
So basically, normally, every anti-doping regulations are supposed to be consistent with the World Anti-Doping Code. So on the merit, they should be always the same. Then it depends who is the testing authority. If a test is initiated by an international federation, then they will have jurisdiction and they will apply their rules. If the test is a national level test, it will be the National Anti-Doping Organization doing the test, who will have then result management and who will apply its rule. There is something a bit special with the appeal to the CAS, meaning if it's an international level athlete, meaning an athlete which is in the testing pool of the international federation, or if it's during an international competition, meaning a competition which is in the calendar of an international federation, then the appeal will be to CAS. Otherwise, if it's a national case, appeal is either to CAS or to the national CAS or National Sports Tribunal, depending on the jurisdiction, on the rules of the country.
Great, thank you. The next question is, if the athletes go through WADA, can you give us some examples of what articles we should apply in anti-doping cases, and what are the different punishments that can be given?
So the different punishment, I would say the standard doping offense, meaning presence of a substance. If it is a serious substance like EPO, steroids, whatever, the standard sanction is 4 years. And then if the athlete can show that he has no intent to dope, it can be reduced down to 2 years. And if the athletes can show that there are further reasons for reduction, either based on fault, can be between no fault or a 2-year ban, or if he provides substantial assistance, as Max mentioned before, he can also get a reduction for that. If it is not such a serious substance, so for example, diuretic, it is a specified substance, so the standard sanction is 2-year ban. It can be increased to 4 years if it is intentional. It can be also reduced. And for other more serious offense, like giving the substance to a minor athlete, for example, or helping someone to dope, then the offense, there is a quite large scale, can be between 2 years and a lifetime ban for the more serious cases.
Okay. Another question is there a statute of limitation for doping cases?
Yes, the statute of limitation under the current rule is 10 years. So 10 years from the offense, but it is enough for the notice of charge to be notified within this 10 years period. So even before the decision, what is important is if the notice of charge is given to the athlete within this 10-year period. It's a very long time, especially when the athlete has to prove the circumstances, how the substance entered his body. It is not difficult if you doped yourself 6 months ago. If now you are notified of a positive test that took place in London Olympic Games 2012, it's almost impossible to prove how the substance entered your body 9 years ago.
Thank you. Okay, another question. If a club tests an athlete and he passes the test, and a day later an outsourced company appointed by a federation retest them and they test positive, would the club be held accountable and fined and sanctioned, and the same as the athlete would be?
No, normally the clubs are not liable for breach of rules by the athletes. If there are too many players, then there will be then the team can be disqualified. If many players, more than 3, I think, test positive. But in some other sports, it's different. For example, in cycling, if there are too many positive cases within the team, then it's possible for the team to be sanctioned or for the team to have trouble to get the license for the following year.
Thank you. If it appears that the player consumed a prohibited substance unknowingly, which was in a medicine given by the club's doctor, is the player liable? And does the doctor have any responsibility or liability?
So then it depends on the circumstances. First, if it happens to the player, he should try to apply for retroactive therapeutic use exemption. Meaning to say, I've used that for a good reason, medical reason, and if it was as an emergency, it is sometimes possible to have an retroactive authorization, and then it means there will be no sanction and no offense at all. Otherwise, if it is not possible, it will depend on the circumstances of the case. Usually, CAS panel do not accept a no-fault ruling in that because they say you are nevertheless liable for what your doctor is doing. The specified substance, it will be between a warning and 2 years. If it is a non-specified substance, it will be between 1 year and 2 years. Don't ask me why there is a difference for the same circumstances. This is how the rules have been drafted. And then the question is whether the doctor might be liable. It depends. The doctors might be liable under their own, I would say, medical legislation if they have done something wrong, because quite usually doctors are not necessarily bound by sports regulations. If they are, and if it was done on purpose, for example, to help an athlete to dope, then of course they are liable and can be sanctioned. And of course, if the doctor has made a mistake, and then the athlete is sanctioned and cannot practice for a certain time, then perhaps the athlete could sue the doctor for damages because the doctor has made a professional mistake.
Excellent, thank you. Okay, the final question. We've actually had a few questions about this, and what they're basically asking is who can actually be the witnesses when the athletes are providing samples and undertaking the tests?
So who can be the witnesses, meaning in a CAS procedure, who can be called as a witness, meaning anyone can be called as a witness. So it depends who has the burden of proof, meaning the anti-doping organization has the burden to prove what happened. So if there is a positive test, it's enough, they don't need any witness, you have the positive result from the lab. If there is no positive test and it is more based about an inquiry, police inquiry, for example, then you will have the witnesses on the side of the anti-doping organization bringing evidence showing that there's been a breach of the rule. Otherwise, the athlete has to bring evidence that he or she has a reduced level of force, for example, so bringing, I don't know, the doctor, showing how it enters the body, the wife, the children, the doctor, the teammates, any possible evidence. And of course, and that's why doping cases are interesting and complicated, and this is good to pass the floor to Robert for the next. It is the importance of the expert evidence, because of course, anything that the athlete submits, there will be a double check to see if this is consistent. Experts will tell you if it is consistent, if the explanation by the athlete is consistent with what is found in the urine, or if this is just an invented story, because it's impossible, for example, that if you have taken a medicine 1 month ago, it's impossible that you have that level of substance in your urine, and then it would mean the athlete has lied and no one.
Perfect. Thank you so much, Claude. Some really detailed and excellent answers there. Just so all of the attendees are aware, some of the speakers are answering questions in the question and answer chat box as well if they didn't have time to respond during their speech. Okay, so now we will move on to our final speaker, who is Mr. Rupert Beloff. Rupert worked in sports media before qualifying as a lawyer. He is a barrister at 4-5 Gray's Inn Square in London and chairman of the International Mixed Martial Arts Federation's Arbitration Committee. He specializes in sports law and is a co-author of Sports Law by Beloff, Kerr and Demetriou. He will be covering the interesting topic, the role of expert evidence in doping cases. Thank you, Rupert. Thank you very much. And can I just say thank you? It's an honor to be invited to speak at this August webinar. As the introduction said, I'm going to speak about expert scientific evidence. And this links in to a significant degree with what my colleagues Claude and Max have spoken about in their talks. And it should come as no surprise that expert scientific evidence often has a key role to play in anti-doping proceedings. And it should come as no surprise because often the prima facie proof of an anti-doping rule violation stems from results of out-of-competition and in-competition testing, as Claude has mentioned in several of the cases he covered in his talk. And indeed, whatever line of defense, and Claude set out several of those, is taken by an athlete,
it may well be the case that expert scientific evidence is of key importance. Now, in the time allotted to me, I hope to be able to cover some, but by no means all of the issues surrounding expert evidence in such cases. I mean, that would demand an entire day's seminar on its own. But what I hope to do is just pick out some key features and pointers for people who are representing athletes and what they should consider in general terms. The second thing to say is that whilst expert evidence is often a key feature in anti-doping cases, it should be recognised that it's not a cure-all for any athlete who's charged with an anti-doping rule violation. And it's worth noting that Court of Arbitration for Sport panels, in common with most arbitral and judicial bodies, are concerned with evidence that is relevant to the issues before them. And just because evidence is provided by an expert doesn't automatically make it relevant. And in fact, CAS procedural rules specifically allow panels to disallow the appearance of any witness or expert on the grounds of irrelevance or limit that evidence. So you can't simply call expert evidence which isn't relevant and hope that it will provide some defence. It's also worth stating that it's almost always the case that if any defence is mounted, the federation or body which has brought the charges will seek to rely on its own expert evidence, because if the test results are being challenged, for example, or it is being said that no, this was an entirely innocent mistake by an athlete, the charging body will want to bring evidence to show that that account isn't correct. So one will usually find that there is expert evidence at least from the federation or body which has brought the charge. But what if one's representing an athlete? Well, the first steps, and these are important steps, are at the earliest opportunity to identify whether expert evidence is relevant to any issue in the case, because as I said, if it's not going to be relevant, panels won't listen to it. If it is relevant, what is the appropriate type of expert evidence and scope? So again, that slightly overlaps with the first point. One has to make sure that the scope of it is relevant to the scope of the issues. And the third point, is an important point, is to consider whether any potential expert witness who an athlete might want to call is actually suitable to deal with those issues. So in other words, do they have the correct expertise? Are they properly able to comment on those issues? Now, it's beyond the scope of this talk to deal with each and every type and specialization of scientific expert who might assist in anti-doping cases, because of course all anti-doping cases are to an extent unique and raise their own particular issues. But by way of example, it might be that an expert's required to comment on concentration levels of a particular prohibited metabolite or substance found in a test result. And that might demonstrate what the likely ingested dose of that substance was. It might be that an expert is called to say whether a prohibited substance could be naturally occurring due to a medical condition that an athlete suffered from. It might also be appropriate in certain cases for expert evidence to go simply beyond simply commenting on scientific data that's already there, but in fact to comment on further tests that have been conducted, for example, for hair sample analysis, which might, in the right circumstances, demonstrate the period over which a prohibited substance has been ingested. The most important thing for a representative to do is to analyse the evidence in a case at the outset and decide what aspect, if any, of their client's case needs to be supported by expert evidence, and then go on to consider type and scope of that evidence. Now, it's worth saying there's often a reluctance on the part of athletes, and I've come across this in my experience, and we'll touch on this when I come to discuss one of the cases that I'll discuss. There's often a reluctance on the part of athletes who are charged with anti-doping rule violations to consider instructing an expert. And that reluctance either comes usually from on the basis that it's going to cost too much, or the mistaken belief that it will be enough simply for them to go and give their account, and any reasonable panel is going to believe that account and let them off the offence or reduce the sanction. The latter belief in particular is often a mistaken one. And as a representative, it is important to have identified what, if any, expert evidence is going to assist the client, and fully explain to the client why they need that expert evidence, and why their reluctance to engage an expert might be misplaced. So where, from an athlete's point of view, is expert evidence likely to be particularly relevant? Well, one category of cases where it's going to be important is where the initial test results are accepted by the athlete, but where it's alleged that the ingestion of a prohibited substance was the result, for example, of ingesting a contaminated supplement or food. And Claude mentioned a couple of these cases. Therefore, no intention to cheat. And again, these are points that Claude covered. In the former cases, establishing the route of ingestion of a prohibited substance is usually a requirement for any successful defence. And in the latter, of that of intention, it's likely to be considered a requirement unless it falls within a narrow band of cases, exceptional cases that CAS has identified. So expert scientific evidence is likely to be important in demonstrating whether a suggested route of ingestion is possible or probable. And I'm going to look at a couple of cases, and just a couple of cases by way of example. And one Claude has already mentioned, and that is Liam Cameron's case, the boxer from England. And it's a case that I know well because I represented Mr. Cameron at first instance in front of the National Anti-Doping Panel. I didn't represent him later in his appeal to CAS. And in fact, there was a disagreement, some disagreement between his legal team and Mr. Cameron as to whether he should have legal expert evidence or not. But as Claude set out, Mr. Cameron was a relatively successful professional boxer. I mean, he'd held the Commonwealth Middleweight Championship. And in April 2018, he took part in a title defence and won his fight. But he was then subject to, in competition, urine testing, which on analysis found that there were metabolites of cocaine, and he was therefore charged with an anti-doping rule violation. And he accepted the charge and waived his right to analysis of the B sample, but sought to argue that he inadvertently ingested the cocaine. And Claude set that out briefly. I mean, it was a fairly unique set of circumstances. He said that he'd undertaken to sell tickets himself in his local area, because that increased his purse for the fight. In doing so, he travelled around various public houses, handled lots of banknotes and touched surfaces which were probably contaminated with cocaine. And that was the only way that he could have ingested it. And that was the only way that there was an adverse analytical finding in his test. He also said that he wouldn't be so foolish as to take cocaine in the run-up to a big fight. That, I'm afraid, is often said by athletes who are charged with an anti-doping rule violation. They say, well, I wouldn't be so foolish as to risk this because I know that I've been caught. That in itself is unlikely to provide any adequate defence. So at first instance and in front of CAS, Mr. Cameron simply relied on his own testimony to these events. He mentioned a case in the United Kingdom where a bus driver had been dismissed for failing a drugs test for cocaine, but it had been found that it had been due to him handling money. But beyond that, he didn't rely on any other evidence and simply put his account forward and said, believe me, this is what happened. The UK anti-doping authorities relied upon Professor David Cowan, who is a renowned expert, And he was able to give evidence as to the concentration of metabolites found in the test samples and showed that it was consistent with either a small dose taken close to the test or a larger one several days before. And he accepted it was theoretically possible for contact with cocaine to occur from contaminated substances and surfaces, and didn't specifically rule it out. But he was of the view that banknotes as a source of contamination was unlikely because they had a very low concentration of cocaine typically upon them. And it's worth pointing out, I mean, in refusing the appeal, it's worth pointing out to several sections of Cass's decision. And the sole arbitrator in that case was Philip Sands QC. And he said that Mr. Cameron faced significant difficulties because he hadn't adduced any corroborating evidence, in this case, likely to be expert evidence. He said the question at the heart of this appeal is whether the appellant's account, which faces real difficulty of being unsupported by corroborating evidence, is sufficient to discharge his burden to prove that the ingestion of cocaine was more likely than not unintentional. And then after considering various authorities and Cass decisions that Mr. Cameron's representative had put forward, said these authorities are not helpful to the appellant. There is patently no objective evidence and no additional elements to support Mr. Cameron's assertion that he inadvertently ingested cocaine by way of contamination from banknotes and surfaces in public houses. The appellant has not adduced any evidence of a scientific nature or otherwise to corroborate his account. And he concluded in relation to expert evidence on the basis of the authoritative expert evidence of Professor Cowan, which stands largely challenged, the sole arbitrator determines that it is unlikely that the banknotes could have been the source of cocaine. And so the outcome in front of Cass was that Mr. Cameron's 4-year ban was upheld. And this case, I would say, is a clear demonstration of a case where the failure of an athlete to obtain and adduce expert evidence, and in fact, Mr. Cameron, because he didn't want to, was fundamentally undermined his defence. One can contrast that with another case which was heard in front of Cass in 2020, which is Lawson against the IAAF, or World Athletics as it's now known. And in that case, Jarian Lawson, who was a US track and field athlete, successfully appealed a 4-year ban following an adverse analytical finding from metabolite of trenbolone, which is a drug that's used to promote muscle growth in cattle. So it's a contaminated meat case. And the concentration of metabolite found was very low. Mr. Lawson contended that he had probably ingested this substance unknowingly from contaminated meat at a restaurant, but he wasn't able to provide actual evidence that the meat itself was contaminated. He couldn't go so far as to say, here is clear evidence that this was contaminated meat that I ate. However, he underwent a number of scientific tests and produced expert scientific evidence, not least of which was hair sample analysis, which demonstrated that trenbolone wasn't detectable in his hair, and therefore he couldn't have been a habitual user of that substance. I mean, he also, just for interest, underwent a polygraph test as well from a former senior FBI agent, but perhaps understandably Cass placed less weight on that evidence. The panel concluded in that case that on the basis of his own testimony and that of the expert evidence that he'd adduced, that this was one of the extremely rare cases where an athlete was able to demonstrate a lack of intent to cheat without explicitly establishing the specific source of a prohibited substance. And they stated, common sense must count strongly against it being a mere coincidence that he tested positive for such a tiny amount of a dangerous and illegally prohibited substance as to be undetectable in his hair, and for no rational benefit, so soon after having eaten beef from hormone-treated cattle. And that case, in contrast to Mr. Cameron, provides a useful illustration of where expert evidence was key in supporting a defence and allowing it to succeed, where in its absence it probably would have failed, and Mr. Lawson's account would have been dismissed as Mr. Cameron's was dismissed. And the final point that I'd like to touch on is this. When selecting an expert, it's important to always bear in mind the role of an expert. An expert is there to give their genuine, unbiased professional opinion based upon their expertise and the evidence that they consider. It is no good producing a partisan expert expert scientific witness who might be biased, or simply sort of will say what the defense wants them to say to support a defense, because without a doubt, under cross-examination during a tribunal hearing, they will be found out. And if their opinion isn't supported by justifiable calculations and evidence, bearing in mind that there is always a reasonable range of opinion in scientific matters, then it is likely that their evidence will simply be dismissed as unreliable and at the best disregarded, and at the worst may in fact undermine the entire defence that's being put forward on behalf of the athlete. And so, looking at time, that's all I think I want to say at the moment, but of course I'm happy to answer questions.
Thank you very much, Rupert. That was extremely interesting. So we just have a few questions here. In a doping case, it's quite general, is it possible for a ruling to be overturned?
Well, yes. I mean, it's possible at several stages, and the speakers have gone through that. I mean, it's what usually happens is the national anti-doping body or whoever's in charge for that particular sport will send a charge sheet to the athlete saying, here's a failed test, an adverse analytical finding. We want your response to it. And if an athlete responds then and provides a entirely credible explanation, it may be that the charges never proceed. I mean, that very rarely happens, to be honest. I mean, one then has, so then assuming it goes to, it is challenged by the athlete and goes to a national panel, that finding is usually subject to appeal. And I think Max set this out. There's usually an internal appeal within country to a sort of higher level tribunal, and then onwards to CAS. Once it is heard by CAS, usually the only way that those decisions are overturned is if some point of Swiss federal law can be brought in, because CAS, of course, is governed by Swiss federal law. And so CAS usually operates as the final arbiter. But there are several stages that an athlete can go through to overturn a decision.
Excellent, thank you very much. And who funds the expert in a doping dispute?
Well, I mean, this is quite interesting. Usually, each party bears the cost of producing the evidence, so it will fall to the athlete. Now, depending on the sport, I mean, you'll sometimes find that clubs can be quite supportive of their athletes and provide funds if they're asked. Mr. Cameron, in the boxing case, I mean, one of his pleas was, I'm impecunious, I don't have the money to pay for an expert. But one of the points actually in front of CAS that the UK anti-doping raised was, well, you didn't ask us if we'd help with that, because it's important to bear in mind that rather like prosecutors in many criminal jurisdictions, anti-doping authorities are there to catch cheats. They're not there to make sure an athlete is found guilty under any circumstances or at any cost at all. And they will produce expert evidence which is, they hope, is fair and balanced. And it may well be that if an athlete can't afford it and makes a case why it would help in a particular case, then the anti-doping authorities themselves might authorize further testing or expert evidence.
Excellent. Okay, we have a question or a statement that states some countries are criminally punishing those found guilty of doping. Does this ruling have any impact on the decisions of other disciplinary authorities?
Well, I appreciate. I mean, the criminal law varies throughout the world, and I know some countries have started imposing criminal sanctions. And I mean, it comes in lots of sports law that matters. Criminal sanctions may apply in bribery and so on. I think the point to bear in mind is that the WADA code and sanctions under that, which have been adopted by various sports federations are essentially a separate system. So where, for example, you might, and I use as a purely hypothetical example, you might be charged under the criminal laws of a country and receive a fine or even imprisonment or something like that for a doping offence if you're using an illegal substance. That is rather separate from the WADA rules and so on, whose concern is keeping sport clean and punishing offenders there. So you will see that sanctions under most anti-doping rules are periods of suspension, ineligibility and so on, rather than fines and imprisonment and so on. So there are only two separate systems aimed at two separate things.
Excellent. Thank you so much, Rupert. Extremely informative. There was one question asked that would probably be best answered by me. Has the Sports Arbitration Centre in Abu Dhabi been activated to resolve sports disputes? Yes, absolutely. We launched in around 2012. So yeah, we're absolutely active to resolve sports disputes. So I think that concludes our webinar for today. I hope you all find it helpful. I certainly did. To the attendees, thank you for attending and for your great questions. We hope to see you at our future events. A big thank you to His Excellency Major General Dr. Ahmed Nasser Al-Razi, who we're privileged to have with us today, and Mr. Faisal Al-Khoury, and of course to our wonderful guest speakers who did an excellent job, not only in the presentations, but in answering all of the questions thoroughly. I just want to also say thank you to our translators who've done a great job. I know it's not the easiest thing to do when we're discussing topics of law. And a final thank you to our technical team. I hope you all stay safe and well. Enjoy the rest of your day. I'm going to provide a link to a survey in the chat. And if you complete this, you will then receive an attendance certificate. And please do check your spam or your junk mail for that. Thank you so much, and enjoy the rest of your day.
Thank you also for being a very nice presenter for this webinar. Thanks a lot.
Thanks a lot. We'll meet in person at some point in the future.
Hopefully. Thank you, Faisal, and thank you all the speakers.